Okay, right, we are now recording and it is Sunday morning, just after 9 o'clock. So we are about to commence with chapter 2. Chapter 2, rather appropriately, is about commencing things. So how to start proceedings, and we've got basically two things to look at. They're either commencing in the PDC or commencing in the Royal Court. We'll think about both of those, and in the context of doing so, we'll also be thinking about different modes of service. So, since that plays a fairly central part in getting the ball up and running. So as we can see then, in the we'll start with the PDC. What we've got there is proceeding by, we've done the jurisdictional stuff yesterday, so we're not going to go over that again, but you can see complete the claim form, pay the fee, which apparently is currently very reasonable, £57. Yeah, so that's that. Lodge the claim with the Grefton Magistrates Court, served by Her Majesty's Sheriff. So that's effectively how that is going to work. And you can see the court gives a receipt which has a hearing date on it, and that's usually 2:30 on a Thursday afternoon. Yeah. So, as it says in 2.2, the summons will be sorted out via the court staff, and there are basically three service methods for the summons section to deal with: A, B, and C. You can see A is direct personal service, so as one might expect, it's physically handed over into the possession of the defendant. B service, not given directly to the defendant, but to some other responsible adult who will undertake to transfer that on to the defendant. And if they can't manage can't manage A or B, by the time we are 2 days out from the hearing date itself, then there is the desperate C service, where it's left in an envelope at the address that has been supplied by the plaintiff on their claim form as the address of the defendant. And we might just note footnote 3 there, this ought not to be the defendant's work address for, I guess, fairly obvious reasons. As you can see, if the information that comes back from the sergeant is that either A or B service has been effected, then the hearing date that was provided by the court staff will be presumed to be effective. But if they've only managed the depositing at an address on the claim form, then they'll call the case on just to see if anybody actually rocks up to say anything on behalf of the defendant, or actually be the defendant. And if nobody turns up like that, then it will be put off for, as it says, effective service. It is always possible, of course, that the nominated defendant has already been in touch with the plaintiff, and the matter has been resolved to everybody's satisfaction. But in that situation, there's an obligation on the plaintiff to tell the PDC, specifically client services, as soon as that is done, because obviously otherwise court staff start to build things into their court diary. So yeah, they need to be told. As you can see then, if the claim stays unsettled by midday of the date of the Petty Court's PDC hearing, plaintiff attends, pays the relevant court fee this time, which is another £120 if it's a money claim, or another £57 in any other case. And as you can see there, interestingly, in footnote 4, if the matter goes to a contested hearing, these become hourly rates. You start saying ouch at that point, I think. Probably not for you guys. I mean, this is probably way below your hourly rates, but yeah. Okay, so how do we go on with this? Well, so before 2:15, bear in mind that the hearing's going to be at 2:30. So before 2:15, the fee has to be paid, and then the plaintiff goes and sits in the public gallery, waiting to hear their case called on. And you can see how that works. They then move into the, if you like, the well or the body of the court to present their cases. Again, in terms of money, we might note footnote 5 there. Party can instruct an advocate, but the advocate's fees won't be recoverable, even if they win. And you can, if the court gives its blessing, use a Mackenzie friend. Is there much use of that in Guernsey? No. No, I was going to say it's becoming quite popular. yeah, not with courts, I don't think, but with otherwise unrepresented individuals. Yeah, okay. All right, so as you can see, if you've managed to get A or B service and the defendant isn't there, then obviously there'll normally be judgment entered for the plaintiff with costs. If there's any B and C service, then the plaintiff may decide to withdraw, but is much more likely to take it in and ask for it to go over to another Thursday to see if there can be effective service done. If the defendant does rock up and tells the magistrate that he wants to contest the claim, he'll be asked to basically give brief details of what his defence is. And if it's thought by the judge that another hearing is necessary, they'll put it over to, as it says, a mutually convenient date. We've then got this, it seems very kind of do-it-yourself really, doesn't it? At least 7 days before the adjourned hearing date, parties must submit 2 copies of supporting documentation at the public counter, or it can be sent by post. Should also serve copies or send copies to the other side, and then bring the originals to the court hearing. I think that's probably that. As you can see, it's possible to get a witness summons if you have a reluctant witness. Yeah, that's basically it as far as the PDC is concerned. Royal Court, proceedings started by tabling a cause. You see that's Rule 10, which is it's the start of Part 3, which is all about commencement of proceedings in the civil rules. As it says, that the formal date of commencement comes before then. Summons notifying defendant is handed to the sergeant for service on the defendant. Yeah. In terms of what the course itself must have, you've got the 3 elements there. Fairly straightforward. And then, as it says, must have the summons served on the defendant to notify him of the tabling of the cause. So there has to be a date and time set for that. Summons must be signed by an advocate. So service is important, and that's what gets us into the next section of Chapter 2. So we need to distinguish between service inside and service outside of the jurisdiction. We've also got various different methods of service. So just to kind of run through those in turn then. So at 2.6, you can see you've got service on an individual within the jurisdiction. So that's done by the sergeant. Again, that may be personal service, or it may be ad domicile, to leave it at the home address. So that's looking somewhat like C service from the PDC. But anyway, so if an address has been provided for service, then obviously it goes there. Yeah, fairly self-explanatory. 2.7, if it's, as it says, a body corporate or a partnership, it's still done by the sergeant, left at the registered office. But if there isn't a registered office, corporate entity carries on business, then it will be at the place of business. And again, there are alternatives that work in exactly the same way as with an individual. With a partnership, it can be a little bit different. So you can have personal service on the partners themselves, or a director or manager of the partnership, or leaving it at the residence of any of those individuals or place of business. All right, estates. Service on estates left by the sergeant at the chambers of the law offices. So fairly straightforward. Excuse me. So the relation of the sergeant, as you can see at 2.10, where the sergeant has effected service, then he makes this statement called a relation to that effect. Not much else to say about that, except if, you know, it's the same as we just saw with the PDC in terms of A or B service or C service. We've also got the possibility of substituted service. Excuse me. So this is to be invoked where your normal methods of service would be impractical or unduly expensive. So if you're wanting to use substituted service, you're going to have to apply for that. And as you can see, then there should be an affidavit in support that sets out the reasons why you're seeking the court's permission to use substituted service. And then that can be done by possibly putting an advertisement into La Gazette through the Guernsey Press. That would be, I guess, the most obvious way to do that, but the rules do prescribe for any other manner that the court considers to be just. Yeah, might be notices perhaps in some public place, I suppose, whether it's thought that it might come to the attention of the intended defendant. So there we are. Service outside then is Rule 8. Reminds me to say that service is dealt with by Part 2 of the civil rules. So yeah, Part 8 then, as it says, you'd need to get an order for service out. Nothing unusual about that. So you'd need to persuade the court, the applicant for service out would need to persuade the court that the matter falls within the court's jurisdiction and it's a proper one for service out of the jurisdiction to be ordered. Almost by necessity, this would normally be an ex parte application. What I know as an ex parte application, you're so young, you probably think of it as a without notice application. But I still remember when these things were called ex parte applications. Yeah, here, yeah. That's great. I mean, you still have plaintiffs over here. This is marvellous. Like going back to my youth. Right, okay. There's plaintiffs there as well. Yeah, yeah. Oh, they also have the and representations and representations. No, representations are a particular type of proceeding. Yeah, but in your kind of bog standard thing, it's still plaintiff. Yeah, yeah. Right. Okay. So as we can see then, one of our many references that we'll be seeing today to Credit Suisse, possibly one of the most litigious entities I've come across in this jurisdiction, or perhaps this is just very unfortunate to find themselves being sued a lot. I don't know. But anyway, so being considered by the ordinary court in this particular case, and as you can see, the observation there was that an overseas defendant should only be joined to a dispute which genuinely and properly arises for determination in Guernsey. And that's the question of whether a matter is properly justiciable before the court, onus being on the plaintiff to satisfy the court that there is a recognisable, as it says, albeit not specific, jurisdictional gateway based on either the nature of the case itself or on procedural requirements. You can see there's a helpful list of factors that might sway the court one way or the other then, including where the key witnesses are based, where the contract was to be performed, if relevant dealings took place, if there are going to be expert witnesses, where they are based, and therefore I guess things around convenience or cost, that type of thing. And not least then is Guernsey law the governing law of the contract.
I was in court and for an application out.
Okay.
And yeah, I don't know whether that's before you felt that they. I don't know whether.
All right.
But
it's just the most recent case.
Yeah. Right.
So is that after the case was
All right.
Is there a new test or is it just a?
I think in that case it goes through all the other things.
Okay. Well, yeah, there is a tendency to, it's kind of like Russian dolls, isn't it, really? Kind of nesting inside of each other. Yeah. Well, we will be working through a number of those in the course of today. So.
And in terms of the exam,
yeah.
If we, because as we all drafted case, go on and on about.
Yeah.
If we know this, is that enough?
Well, I think I might have said this yesterday, so I apologise if I'm repeating myself. But obviously we don't know who's setting the exam. We don't know, therefore, what kind of criteria they're going to be using to assess. But from my point of view, if you've got a study guide, that ought to be the basic foundation. So if you're showing that you understand that, then that should get you through. In terms of doing better than that, the more layers you can build on top of that, yeah. Okay. Yeah, so forum convenience or forum non-convenience are things that we'll be looking at, I think, probably another couple of times in the course of today. So as it says there, if the defendant has, in 215, if the defendant has submitted to the jurisdiction of the court, then he loses the right to apply to have the service out set aside against him. He can still seek a stay of the proceedings in Guernsey on the grounds that there is forum non-convenience, but the onus will then fall on him to establish that fact. All right, so we've also got the possibility of absentee proceedings where the court has not decided to give permission for service out, or the plaintiff doesn't have an address to use for service, and we're not going apparently for substituted service. Then, as it says, the plaintiff can apply to call upon or evoke the defendant, and that will be very much like substituted service, an announcement in La Gazette. The court grants the sergeant, as it says, a term a career which enables him to write to the absent defendant and seek to obtain instructions. How effective that is depends on whether actual contact is made, and different periods of time can be allowed, as it says, where it's thought that the defendant is in the UK, then maybe 8 days would be allowed for the sergeant to make contact. Then at the end of that period of time, the sergeant has to come back before the court. If he has made contact, then all well and good. As it says, he will have given the defendant a list of Guernsey advocates who could defend him, and then everything goes on as per usual. But if no contact has been made, then the sergeant reports that fact, and effectively you have a default judgment against the defendant, although it might be questionable how that's going to be enforced. Yes. Well, as it says just at the end of chapter 2, there is a 6-year lifespan as far as the judgment is concerned, and that is possible to apply for its extension. But yeah, it's a little bit kind of whistling in the wind, isn't it, really? So there we are. But you know, it's the way that things are. Yes, and yeah, I guess I go for the publicity option. Yeah. Well, it could happen. All right, chapter 3 then. Pleadings and parties. So first of all, the cause. That is our kind of main document as far as actually plaintiff starting things off is concerned, because it's the cause that is annexed to the summons which is served on the defendant to notify the defendant of the proceedings. The cause then is tabled before the court, and that's provided for in Rule 12. And as it says there, essentially it's doing the job of a statement of claim. Right? So it's a formal document, and as 3.2 points out, it has to establish the material facts which are being relied on, but not the evidence. It has to identify the relief or remedy that the plaintiff is seeking, and it has to give an address for service or an election de domicile. Has also to be signed by plaintiff's advocate unless he is a litigant in person, and that's basically that. So all papers must be lodged by 4 p.m. on the Wednesday preceding the Friday ordinary court. I mean, I have to say myself that these kind of little incidentals, like which day and, you know, is it 4 o'clock, is it 2:30? I would personally find it inconceivable that there would be a question in an exam that required you to demonstrate that, I don't know, level of knowledge. Yeah, but anyway, there we are. Well,
Really, really important.
oh, of course, yeah. No. All right. Yes. They just rock up. Yeah. Yeah. I mean, obviously, yes. They'd head to what was it called, client services, I think, Flushing, and make themselves known.
I think we do
Yeah. Right, okay. Tabling is important. If the plaintiff doesn't appear, then the court could dismiss the claim. If the defendant doesn't appear, then the court can enter judgment against him. So turning up for the tabling is quite important. The defendant, as it says, can either appear in person or through an advocate, and there are 3 possible oral responses the defendant may make. So you can see, would say present, if the matter is not defended or if there are insufficient instructions and you're seeking a short adjournment. So, you know, we're here, don't enter a default judgment, anybody. There's this, I don't know, do you know, how do you pronounce this? Bers Amerce? So I'd pronounce it, but I don't know, because it kind of looks Italian to me. So, all right. Yeah. Well, you've got, that's, I guess, footnote 7 perhaps gives us more of an insight into how it might sound. But, yeah. Yes, that's something I only realised last night when I was doing a bit more prep. That yes, on my version, I didn't realise this, but they reset for every chapter. So yes, no, all right. Well, the 7th footnote. Yeah, sorry. Yeah, no, I realised this last night because I was looking. I had to look something up. One of the footnotes referred. It said, "See note 243 above," and this was on. When I looked at it, it was actually on footnote like 15 or something that it said that. I thought, hang on a minute, something's gone wrong here. But yeah, so apologies for that. I don't know why it's done that, but yes, they have reset. Yeah, okay. So yes, and that is to be used, as it says, where it's going to be no defence entered, defendant consents to judgment. And then I guess the more interesting one for our purposes is inscrite, which means the matter is going to be defended, and it will then be, the cause will then be inscrite or inscribed on the roll des causes à plaider or pleadings list. Defendant provides an address for service. As it says, failure to do so, this election de domicile, failure to provide that may end up with the court entering judgment against him, and that's prescribed by Rule 15. So, having gone along and presumably shouted out inscrite to indicate that the matter is going to be defended, we then move on to the defence. And as it says in the 10th footnote in this chapter, sometimes in judgments referred to as the defences, plural, or les défenses. But anyway, that has to come in no later than 28 days after this hearing in the court, although that can be extended by, as it says, simple agreement between the parties by up to 3 months. Now, I would have to say myself that I suspect these days, with the overriding objective and the active case management that the court's encouraged to engage in, that period might be, you just kind of fanny about waiting for the 28th day to arrive, you know, and then expect a 3-month extension that the court might say, why haven't you already sorted this out? But yeah, anyway, yeah. I mean, all I'm saying is I don't think you could just presume to get that. I think you're going to have to show some basis for it. So, as it says, if the defendant wishes to advance the defence before that 28th day, notifies the plaintiff by means of a signification. 3 copies will be lodged with the greffe, copy of the plaintiff's cause attached to each one, so everything gets joined up at that point. Obviously serve a copy on the plaintiff, and if that doesn't happen, then there's likely to be an application for a default judgment pursuant to Rule 17. And each week, all of the defences have been lodged, collected together, and then formally tabled on the Friday morning sitting of the ordinary court. Not necessary for anybody to be present at that point, but the idea then is that unless for some reason the court directs otherwise, the matter then shifts from being inscrite on the pleadings list to being inscrite on the witness list, or you can see the role de cause on proof. So what goes into defences? Just as a small point, if we just skip over to 3.7 at this point, and then we'll come back. So 3.7 you see, if you are pleading exceptions or exceptions, they have to be pleaded separately from the nuance and prétention, and that's prescribed by Rule 16. And it turns out on my investigation that a nuance is a denial of law or fact, or mixed law or facts, and a prétention is a counter allegation of mixed fact and law. So who knew? You can also have averments. So the positive case on behalf of the defence, obviously the defence could consist of admissions, not exclusively, otherwise it's not really doing much of a job as a defence, but try to, if you like, refine the issues, the contested issues between the parties. And of course, there may also be a counterclaim against the plaintiff. So that's your kind of basic content as far as the defence is concerned. But then if we come back to 3.5 then, as we said, defence may contain an exception. So two types, exception de forme and an exception de fond. Exception de forme, nothing too threatening really as far as that's concerned. It's simply saying we don't understand what your beef is with us here. So we cannot actually put in any kind of meaningful defence. So it says works a bit like a request for further information, which is also provided for under Rule 60 and will be treated as such. So that's how that's going to work. Not really much of a defence, but just something that puts the plaintiff on notice to give us a bit more detail so that we can actually work out whether we want to make admissions, deny, or whatever it is that we want to do. So that's not very interesting. The more interesting one is the exception de forme, which has three forms. So you can see the déclinatoire, which is an assertion of no jurisdiction. And obviously that takes us back to thinking about forum non-convenience arguments. The exception dilatoire, which basically says that the matter is being raised prematurely. So you've got the example of a debt that has not yet fallen due for payment there. Or an exception péremptoire, alleging that the claim is null and void, typically because the defendant is raising an argument about prescription. Case, very repetitive case, repetitive in the sense that, as I said yesterday, I seem to type out the words Yadahig and Credit Suisse many times whilst putting this study guide together. So if I didn't say it yesterday, I'm going to say it now. It's probably a very useful case to have a look at. So as you can see, the defendants pleaded exceptions, but because there were multiple defendants, they took kind of different, sorry, yeah. Yadahig, so I'm in 3.6. Yeah. So yes, so some defendants said that they were pleading or labelled them as exception de fond. Others simply, were a bit more specific and either defined them as déclinatoire or péremptoire. You would have thought that these are different points, but the court said that nothing turned on that. So they don't really care about the label. It's more the argument that supports it, I suppose. That's the important thing there. And as it says, the common contention, once you stripped away the classifications, was the plaintiff's claim should be struck out as disclosing no cause of action, and it was prescribed. Okay. So we've got this reference to the judgment by Lenny Hoffman in Cherub and Channel Islands Aero Club, tested whether an exception de fond can succeed or not, whether there are no facts which might be proved at the trial, which would allow the plaintiff, then obviously slight digression there, no admissible facts consistent with the pleadings which could be proved at the trial, which would allow the plaintiff to succeed in the action. As I say, as the commentary makes the point, both of these cases are pre-2007, so it might well be that perhaps these days nobody would be pleading this point or these points as an exception de fond, but instead applying for a strikeout on the grounds that there are no reasonable grounds for bringing the action. But I guess that remains to be seen. An example of the latter you can see in the case, I don't know which number it is, it's the 22nd footnote, Saville AD4 Limited and Marlborough Trust. Yeah. All right, last point on exceptions then, as you can see at 3.8, pleading the exception de forme, as I say, it's not a significant obstacle to anybody, it's just asking for better information or more information. So pleading the exception de forme does not delay the matter being inscribed onto the witness list, but pleading an exception de fond means that the matter cannot be inscribed on the witness list until such time as the defendant is able to also put in a substantive defence, because you might have simply banged in an exception de fond and not bothered to put in a substantive defence because you're hoping that that will do the job, just kill it off at that point. Then, once a case is inscribed on the roll or the witness list, plaintiff's got 14 days to apply to the court to set a date for a case management conference. That is something that we will pick up in a subsequent chapter, and we might just note here that case management conference might arise in by other routes than simply the plaintiff applying within 14 days. But we'll come back to case management conferences a bit later on. All right, so we briefly identified a couple of minutes ago that the defence might, amongst other things, include a counterclaim. So you can see that this is governed by Rule 30 of the rules. I say you can see it, that's the footnote that sits alongside counterclaims, but I don't know, it's number 24 for me, but I hesitate to think what we're up to. For you guys, 150 something? 180, all right, thank you. So as you can see, cross action, I mean, there's nothing, I don't think there's anything that we don't understand about counterclaims here. So the court can decide that the matters in the counterclaim really give rise to an independent action that should be dealt with separately. It can also strike out a counterclaim. Also, 3.10, even if the plaintiff's claim has run into heavy ground, it's been stayed, it's been discontinued, or it's been dismissed, or judgment has even been entered, so good news to the plaintiff there, a counterclaim can stay on the pleading list and proceed potentially to trial and resolution. So 28 days after the counterclaim has been inscribed on the pleadings list, plaintiff must table his defence unless the court orders otherwise. Yeah, all right, so really the kind of the boot is on the other foot. Once the plaintiff has tabled his defence, so it's going to be contested, then it will be inscribed on the witness list. And if the plaintiff fails to table a defence, then the court is likely to enter default judgment on the counterclaim in favour of the original defendant. Also possible for the defendant to plead a set-off, as indicated in 3.11. So that might be a matter of contractual provision. And as it says, the usual effect is that all you can do is to seek to recover the balance after the set-off has been accounted for. So this apparently has been around for a long time. I think this is my only mention of Potier in the entire study guide, so it's probably worth me just drawing that to your attention. So according to Potier, if we're looking for compensation or compensation, the debts must be of the same kind. They must be certain and liquid. So as it says there, a genuinely disputed claim can't be set off against an undisputed claim unless it can readily be proved, and an unliquidated sum can't be used in a set-off. Both debts need to be presently due and payable. So that's basically that. Yeah, okay, just checking that I didn't want to skip over third parties and come back. All right, so let's quickly think about third parties and then move on to the way pleadings then pan out and possible amendment of pleadings. So as you can see, it's possible that a defendant may wish to make a claim against a third party, may be seeking an indemnity or contribution from them, in which case he can add them as a third party by serving them with a summons, adding them as a third party. Could also see their defendant can use this procedure where claiming against a non-party for any relief or remedy that's related to the original subject matter of the action is substantially the same as some relief or remedy sought by the plaintiff. I think that's fairly usual. Should be used to that from studying civil procedure elsewhere. And third situation, defendant may use third-party procedure where he considers that any issue related to the original subject matter of the action ought to be determined not just between himself and the plaintiff, but also between either or both of them and a non-party. I suppose I might just flag up at this point the interpleader proceedings that we'll be looking at in a separate chapter a bit later on. So it's possible for third parties to third party other people and have a kind of daisy chain of them. And anybody that comes in on that basis will be referred to as a third party. And as it says in 3.13, when you are added as a third party, you are effectively a defendant being sued by the party that added you. Everything follows naturally from that. When the original action is resolved, then the court can give judgment in the matter between defendant and third party. Also, if the court rules against the defendant, so the defendant loses the original action, but for the defendant against the third party, so in other words, you are liable to the plaintiff, but you can recover a contribution from the third party, then as it says, the judgment against the third party can only be executed if the court gives leave to do that. If the third party messes up procedurally, and therefore a default judgment is entered against them, or indeed for some reason there's a hearing which results in a decision on the merits going against the third party, that will not have any impact on the claim between the plaintiff, the original plaintiff, and defendant. Right, okay, as I say, I've mentioned interpleader, so we'll come back and think about that a bit later on. I think it's chapter 9, if memory serves me correctly. All right, so we've got the cause, which is like a statement of claim. We've got the defence, which is very much like a defence. And thereafter, then, what else can we have? Well, after the defence, if there is one, the next turn is for the plaintiff, and that will be something called a replique. And then, I suppose what we might describe as a reply, but anyway, it's called a replique. And the defendant can then come back again with a duplique. As it says, if you're a litigant in person, you don't have to call these things by these names, as long as everybody understands what they are. So that's your basic kind of sequence as far as pleadings are concerned, and they may be amended, as we can see at 3.15. So, for example, the Appleby and Maud judgment, I don't think is of any great interest for any other reason than that there was a re-amended replique, which I think is about as esoteric as I've come across here, but anyway, there we are. No, you can do better than that. Okay, but it's yeah. I mean, if you're in that situation, I mean I'd be quite happy to be in that situation if I was defending against that, because it suggests to me that the latest case is built on shifting sands a little bit. No one's too sure exactly what the hell's going on. But yes, all right, discretion is the better part of valor, as they say. So we'll say no more and move on. So as you can see, you can't amend unless everybody gives consent or you get leave from the court. We see there a reference. I think we might have had one or two references yesterday to Jeffcoat and Spread Trustee. I think I can actually type that blindfolded in the dark room now. So Jeffcoat is a case that comes up a lot in the study guide. So yeah, in that case, the bailiff said the principles stated in the Court of Appeal judgment in Ogier against Grand Havre Holdings in 2000 represent the current position, which I think they still do, as far as amendment is concerned, and that was said to be notwithstanding they predated the introduction of the Royal Court civil rules in 2007, along with the overriding objective. So as you can see, the first thing really that was said in the Ogier case is depends on what justice requires. It's case specific. Too much, like prescription in a more general non-limitation type sense is undesirable. So broadly reflect the existing practice of the courts of this island. First would not be just to allow an amendment if it would defeat a plea of prescription that would otherwise be available. That seems fairly reasonable. Secondly, an amendment shouldn't be allowed if the case that would be introduced by it can be seen to have no realistic prospect of success. So there's kind of futility point there. And then thirdly, leaving aside any prescription issues, the mere fact the change effected by a proposed amendment would involve introducing a new cause of action or would substantially alter the character of the proceedings is not a reason for refusing leave to amend, always provided that the change can be made without inflicting injustice of a kind incapable of being compensated for by an order of costs. So in other words, you may end up having to pay your way through to an amendment. So 3.16, whether a proposed amendment would indeed add a new cause of action, the court needs to look at the factual matrix and not simply a label there. So if it doesn't introduce any new factual circumstances, it won't be regarded as a new cause of action, maybe perhaps more as a redefinition, which doesn't seem at all unreasonable to me. The court has a discretion whether or not to allow the amendment. But if it would add a new cause of action, then there may be concerns around prescription. So 3.17, the second point that came up from the judgment in Ogier in the Court of Appeal, no amendment should be allowed if it would have no realistic prospect of success. You've got this reference in Jeffcoat to the this passage, probably from the judgment of Lenny Hoffman again in Cherub Investments against the Aero Club, which I think actually is the same quote that we just looked at, so I'm not going to go through that again. But it would be significant perhaps to look at the ABC there, particularly the A. The court has a wide discretion under Rule 59 of the rules to permit an amendment where at least one party does not consent to it, and a reminder of the overriding objective. Cases to be dealt with justly. So again, D in this very long list of points basically says that it's case specific and introduces the point about timing. So special importance where a party seeks to make a late amendment. E, obviously, if your overriding objective is to deal with cases justly, then yes, generally you would be saying, I think that amendments should be allowed because that's what gets us to the heart of the dispute between the parties. F brings up the prescription point. G, I think, again, we've already looked at that. H, we've already looked at as well. Yes, J, I think that makes an important point. If the amendment does introduce a new cause of action and there is a question mark over prescription, obviously it's important to understand the effective date when the matter was added. So as you can see there, it's the date of the application to amend. But if the amendment is allowed, then it's deemed to date back to the original proceedings. So, and that's, as the footnote there indicates, the date when the plaintiff delivered the summons to the sergeant for service. So that's when your kind of prescription point becomes significant, when not when the matter is tabled in the Royal Court, but when the matter is delivered to the sergeant for service. All right, K in this list. Obviously, in terms of, I've called it limitation period. I've probably been a bit cavalier there. I probably should have referred to it more specifically as a prescription period. So I will change that. Yeah, so court disregards any period during which the plaintiff was under an impediment or empêche d'agir. we'll look at that a bit later on today. L we've already covered, and M I think doesn't say anything new either. Yeah, 3.18 I think is just a kind of technical list of technical pointers, which I don't think we particularly need to go through at this point. In terms of using track changes, kind of little comment boxes in the margins, and then you've got the points from the Lieutenant Bailiff, Her Honour Judge Marshall, on formatting. So saying that judges like to see, they want all the pleadings, they want to see where the changes have come in the pleadings, so they can kind of follow the family tree of the issues there. So they might well want a clean copy. This is, the case is going to the jurats, and God knows they'd only want one version, the final version. So that would be all amendments kind of accepted. Yeah. It's just fading away, isn't it? I may have done, I don't remember.
Yeah, that'd be brilliant.
Yeah. Yeah.
I hope it wasn't an after dinner speech.
I went to it, it was just all common sense.
Yeah, well, these things usually are.
Yeah.
Yeah.
But they're not,
Well,
not always
I was going to say, it's not everybody has common sense.
If people have,
Yeah.
they have.
Yes. 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 I mean, I think that's exactly what she's drawing on. That, so yeah. Okay. No surprises. No. Well, I suppose that's the point. If you're familiar with the system, then yeah, and presumably she's just putting out a plea for everybody to adopt that system. Yes. Okay. All right. So yes, striking out then. So under Rule 52 of the rules, then the court has the power to strike out a pleading or to strike out part of a pleading, and there are 4 grounds for a party to seek striking out. So discloses no reasonable grounds for bringing or defending an action, abuse of court's process or otherwise likely to obstruct the just disposal of the proceedings, the party whose pleading is non-compliant, or for want of prosecution. This is a discretionary remedy. And again, the footnote reference that I have there takes me down to Rawlinson and Hunter Trustees and Investec Trust. I almost have the feeling that although I'm referring to some of these cases multiple times, there are some cases that just kind of go on and on and on. So when I think of Jersey, I think of the Crociani litigation, which I had thought at one point it kind of finished, but it seems to like rise from the grave every so often. So it's just I think I said about three years ago, I said to the students at the JLC that it was the case that kept on giving, and it's still going. So I don't know how much money there was in the first place, but I'm sure it's made a considerable dent in the money that was available. This is what, Eduardo? Yeah, Eduardo. Yeah, is it Eduardo? Anyway, yeah, the mummy. Okay, yeah, but Rawlinson and Hunter Trustees in Investec, as I'm sure you realise, seems to come before the courts quite a lot. The Royal Court, the Court of Appeal, I think it's been up to the Judicial Committee. Yeah. So that's probably a good one to have a read through if you're in an otherwise deserted house, nothing to do. Yeah. There's lots of different things going on. Yeah. Okay, so taking those in turn then, no reasonable grounds for bringing or defending the action. As it says, the test that's often applied in English cases is whether it's plain and obvious that there's no need to be a trial. Cause of action that's unknown to law will be struck out. You'd imagine that sort of thing only very seldom happens. Maybe the sort of thing where you've got a litigant in person. I suppose that's a possibility there. It says, so this is Rule 52.2, specifically paragraph A, and the relevant rules were set out by the bailiff in Tranquility Holdings and in Vista Real Estate. The claims which are suitable for striking out under this particular paragraph of the rule include those raising an unwinnable case where continuance of the proceedings is without any possible benefit to the respondent. That's the respondent to the application to strike out, obviously, and would waste both sides' resources. So this is perhaps just a very straightforward illustration of the overriding objective in operation. Second point, principal test that the court will be asked to consider is the case bound to fail? That party's case, is it bound to fail? As it says, that will be a high threshold. The mere fact of it being weak will not suffice to strike it out. If a statement of case, so that's for our purposes a cause or a defence or a replique or a duplicate, raises a serious factual issue that can only be resolved by hearing oral evidence, not suitable for striking out, that may be a situation perhaps where it's simply a he says, she says type of thing, so you've got a credibility battle going on. So you need to actually see and then assess the witnesses in person. So if a statement of case is defective, and that's your basis for saying it doesn't disclose any reasonable grounds, then first, before striking out, which is obviously a relatively serious step to take, consider if an amendment might resolve the matter. If so, try and do that. It says particulars of claim or the cause may be so badly drafted they fail to reveal the case, and they can be struck out. But again, I guess we might try and join up the dots a bit and say that that would look like the defendant ought to have pleaded an exception de forme there and seek further better information as to the details of the claim. So if you were applying for a strikeout and you hadn't pleaded an exception de forme, then the court might simply order further information to be supplied and maybe adjourn the application for striking out, see what the plaintiff comes up with. Yes, all right, so I think that's probably that. So the second ground, which is always an exciting one, is abuse of process. So as it says, this the assessment of this can involve a large number of factors. Although the case that I've cited there is an English case, it was cited with approval in Rawlinson and Hunter and Investec. So see, the deputy bailiff considered that reliance could be placed there because the wording in the civil procedure, the relevant civil procedure rule, is identical on this point. So burden of proof fairly obviously rests on the party alleging that there's an abuse of process. Yes, so if the complaint is that you could have raised this in other earlier proceedings, then as you can see, there's a whole list of principles to apply there. Is the party's conduct to bring a second action a misuse or abuse of process? In terms of merits here, that's the merits that relate to the issue. What else do we need to think about? I think it's all pretty straightforward. Yeah, so point D, I guess, hold that a matter could have been raised in previous proceedings, therefore it should have been, and the new proceedings are necessarily an abuse is wrong. I think because it's not showing a proper consideration of the different factors and circumstances involved, it's too simplistic there. Cutting and pasting, tempting thing to do, or dragging and dropping, does not of itself, or might be indicative, but it doesn't of itself suggest that the second claim should have been made during the previous one. I think I've missed out some letters there. So the overlap must be assessed. not asked, with reference to the substance of the previous claim and the new one. So what else do we think about from this? Oh yes, H. H is an important one. Shouldn't keep additional claims secret just because they might involve additional and possibly complex issues. It's cards on the table, which is all part of case management, which is of course, again, coming back to the overriding objective. I, public interest in achieving finality in litigation. So there is a degree of closure there. Although that's to be balanced, as it says, against the freedom, especially in complex commercial matters, to choose who to sue in which action. It's an incredibly long list. Yeah, yeah. It's well, halfway. Yes. Yes. Yes.
What degree would you expect if you were
Yeah.
us to familiar with A through L, A through M, A through
I think, yeah. Well, I mean, let me put it this way. If you can demonstrate that you have a photographic memory, then you should get the benefit of that. But on the other hand, yeah. On the other hand, I think as long as you're displaying that you have the sense of these, then I think that's perfectly fine. Yeah. I mean, I don't think anybody's going to be sitting there going, there are, what is that, 12 different points on the list that I was just talking about. There's 12 different points there. If you don't make 12, then something's gone badly wrong here, and yeah, this person should never be admitted to the bar. I can't see that being an issue really. So no, these are almost insanely long lists. It's great to sit there and read them, but in terms of anybody actually remembering them and then repeating them, no, I don't think.
Yeah, basically.
Well, I mean, again, as I say, if you wish to, I mean, I'm only replicating the way they're set out in the judgment, which I think is important as far as the study guide is concerned. But if you want to show that you have independently applied your mind to the listings and the classification that's been used, and you've come up with a shorter and more effective way of communicating that, then yes, I mean, I'm sure the markers will not only be grateful and impressed by that, but they'll probably be ripping it off in terms of, I mean, not me, because I'm not practicing, but yeah, if there is another marker or markers where I practice, then they'll go, yeah, well done, whoever candidate number 5 is. Yeah. I mean, I'm assuming that everything works on an entirely anonymized basis as far as the exams are concerned, but yeah, but it's a little world, isn't it? So yeah. I do sometimes get a sense of that. I say no more. Right, okay. So yes, all right. Our third ground for striking out was being non-compliant then. And as you can see, the most obvious way to deal with this, if we're sticking with the overriding objective, is perhaps just to allow a bit more time. And it might well be the case normally that that's exactly what the court would do. It might also make an unless order so that perhaps concentrates the mind of the non-compliant party a little bit more, so that they know exactly what sanction will be applied to their case should they not comply. But as it says there, then when there is an unless order that results, it's not complied with, and that results in the proceeding being struck, or the pleading being struck out, then any other party can apply for judgment and costs against a party that is non-compliant. And then fourth reason, striking out for want of prosecution, aka insanely long delay in progressing the matter. So basic test, again, nothing surprising here. Has the delay been inordinate, inexcusable, and prejudicial to the defendant? And in a footnote. I know not what the number might be, but it's the 57th one of this chapter. You have a right. Thank you. You have a reference to Ogier and Grant Avra Holdings again, which we've already mentioned once. So the frankly mind-boggling delay of 11 years since the action began. You kind of wonder who had charge of the file, really, on that one. But yeah, I'm sure it would be possible to find out. And any trial that was going to take place would be 17 years down the line, with extensive oral evidence needed. Well, I mean, people's memories don't last that long, do they? Yeah, created, surprise, surprise, substantial risk of an unfair trial. So the claim was dismissed there. Yeah. Well, yeah. I mean, obviously that's an extreme example, but it's quite frightening that it exists in the first place. No.
Oh, beginning of it.
Yes. All right. So there we are. You can see the onus is on the defendant to establish inordinate delay, and it's then for the plaintiff to show that there's a reasonable explanation or justification for it. All right. Peremption. Peremption is a kind of it's a kind of more specific example of what we just looked at, striking out for want of prosecution. So peremption 3.25, no procedural step is taken in relation to an action within a year and a day, then customary law regards as peri-me, but nothing automatically happens in that situation. It's for the defendant to apply for it to be struck out on the grounds of being peri-me, and if he does, the cause is extinguished. So as it says, defendant has to raise that before taking any further step. If he does take a step, then he's at risk of being held by the court to have renounced the peremption. 3.26, obviously we have to think about the prescription period as opposed to the whole year and a day thing, because the prescription period may not have lapsed or run out at that point. So even if that action is struck out as peri-me, the plaintiff can just start again, which kind of begs the question of what was the point of making the application in the first place, but I suppose it might be enough to put them off. So as you can see, the plaintiff has to apply to the court for an order restoring the action, and that's provided for by Rule 86. Yeah. Okay, I don't think there's anything else I wanted to say as far as that's concerned. Apart from that rather obscure point about application by a plaintiff to restore and an application by the defendant to strike out for want of prosecution. Two distinct applications, and the application to restore should be addressed first. That seems quite logical to me. But yeah, you can see how the two are related to each other. So as it says in 326, this is something that may well be on the way out, because the court now has powers to actively manage the case, and there is a specific requirement in Rule 1, Para 2 to ensure the expeditious progress of cases. So in other words, these days, you can't just let things go. You can't have the parties just agreeing between themselves to have, oh, well, let's reconvene in 6 months' time then when we feel like it. I think, if memory serves me correctly, there is a case whose name certainly doesn't come back to me off the top of my head, but a Jersey case that says that a normal piece of litigation you should expect it to be resolved within 12 months. If it's a complex piece of litigation, you should expect it to be resolved within 24 months. So there you go. We might regard that as a guide. I don't know. Yeah. Well, it might well be like an aspiration rather than anything else. Yeah. All right. Right. I can see I've gone very obscure in paragraph 326. So, factors for the court to consider on the exercise of its discretion under Rule 86 are those that are set out in the Guernsey Annandale Tile Company case, which is a fairly old one now. It's, what is that, just over 20 years old? No, yeah, 20 years old. But you can see it, the relevant bits are in the Brawn and Water marketing, which is much more recent, 2013 at paragraph 33, although I know I haven't actually said what they are, hence my reference to going a bit obscure there. That's not very helpful, is it, really? So, I think, yeah, Singleton and Duncan, 2007, so that predates Brown, but factors to consider where there's an application to restore. So this is where it's already been kicked out as being perime, and the plaintiff wants it put back. Positions of the parties, what would happen to either of them if it is restored or is not restored, why it became perime. So, for example, if the plaintiff had just been not doing anything at all, I mean, I suppose there might be some finger pointing between the plaintiff and the plaintiff's advocates, maybe a change in advocate that is now bringing the application to restore. But as it says, that there might be special Guernsey factors to consider, such as problems with getting legal representation quickly or delay in obtaining reports as contributing factors. And the court is simply trying to do what's fair in all the circumstances. Yeah. It's, you know, it's not for me to say. That's I mean, I have seen references. Well, not so much. It's kind of like, yeah, Jersey. There's this thing. Sometimes they have this thing. Yeah, this tag called the Jersey Way, which sometimes they seem to wear as a kind of badge of pride, and other times they kind of deprecate as nonsense, and nobody talks about that or knows what it is or anything else. They seem quite ambivalent about it. I suspect this is heading down a similar path. Yeah. All right, Raye, which obviously is a procedure that originated in the northeast of England. No? All right. Thank you. No, well. Yeah. No, it's all right. We'll discuss. Anyway, yes, it's kind of like the non-identical twin brother of perime. Yeah. So as it says there, it seeks to address delay. I'm not going to talk about it. Gordon Dawes observed 15 years ago that the Gress seemed to have abandoned the process. So it's included for, I think, historical interest rather. Yeah. Now then, appeals on striking out. I note that I have written in there, and unfortunately this is something that's going to come up a lot. It probably doesn't make a great deal of difference, but yeah, appeal on a striking out decision is the second paragraph 327. So there's a paragraph 327 just before that, but unfortunately the paragraphs thereafter assume that the second paragraph 327 was paragraph 327. So you'd either just ignore that or renumber everything. Good call. Yeah, yes. Why didn't I think of that? Yeah, okay. So appeal against striking out then, as you can see, factors again from Rawlinson and Hunter against Investec. Immaterial factors, I mean, this is just bog standard, isn't it? Immaterial factors considered, material factors not considered, error of principle, or it was just a conclusion that was not open to the judge to reach in all the circumstances. So, as it says, there's a fifth possibility. Court may also interfere where the ground of appeal is that the judge at first instance balanced the factors inappropriately, but that's going to be quite a rare one to use. All right, requests for further information. We did encounter them fleetingly when we were looking early in this chapter at pleadings and thought about pleading an exception de form. So that, as it says, is now to be regarded as a request for further information and you should therefore proceed in accordance with Rule 60. So initial expectation is an informal request to the plaintiff. You know, I don't understand. Could you please explain it better to me? And if that doesn't work, then an application under Rule 60 to the court. As it says, the application may just be for this order, but you can also make an application at a case management conference. There'll be a deadline. The party that's required, usually the plaintiff, of course, must file their response with the GREF, serve it. And I think that's probably that. It may be necessary to amend the pleadings as a consequence, which, as we know from looking at amending the pleadings, is either going to require everybody to consent or to get leave from the court. All right, judgment in default of defence. Not a lot that we need to say about that, I think, really. But if we think all the way back to when the summons with the plaintiff's cause attached to it was handed over to Her Majesty's Sergeant for service on the defendant, it says that summons should warn the defendant that if he fails to table a defence, then the likelihood is the plaintiff will apply for judgment to be entered against him. That is a warning required by Practice Direction 1 of 2008, which is quite a useful practice direction to have a look at. And as you can see, if the court does give judgment in default of defence, the defendant can apply to have that judgment set aside or vary the terms of the judgment. So court must be satisfied that the defendant has a real prospect of successfully defending, or there's some other good reason why the judgment should be set aside and the defendant allowed to defend. I think that's very similar to the analogous provision under the Civil Procedure Rules in England and Wales. So as you can see, court may be satisfied if there's a certificate from the defendant's advocate that there's a real prospect of successfully defending. Presumably the defendant's advocate is in a fairly well-informed position to make that judgment. But there should also be evidence in the form of an affidavit to support that opinion. And as you can see, again, timing is important, as it often is. Court will have regard to whether the application was made promptly. Right.
The certificate in itself, is it a letter?
Yeah, I don't think there's any. I haven't seen anything that formalises that. I mean, it might well just be an affidavit from the advocate to testify to that effect, because it's not at all. It's not that unusual for advocates to swear affidavits, depose affidavits.
Well, the advocate himself wouldn't. It would be the person who's not presenting the advocate in court.
Well, yes, and no. Yes, I agree with you. In principle, you're right. But I have evidence from another jurisdiction not too far away that people do that there. So I agree, it shouldn't happen for ethical reasons apart from anything else, but sometimes it does. Yeah.
Well, it's in a way sense, isn't it? And so, but the certificate, there's no rules about what the certificate is.
Not that I've seen, no. Yeah, I mean, certificate, I mean, the language I've used there is certifies, which would imply that there is a requirement for a certificate as such. But as I say, I think an affidavit would do the job, possibly a letter. But I think whether it's an affidavit or a letter, you're still running into potential ethical issues there in terms of being a source of information as opposed to being an advocate. So, okay, yeah, so let's just finish off chapter 3 and then we'll have a short break. So putting things together, splitting them apart, consolidation and severance. So governed by Rule 31. And as you can see then, there may be multiple actions proceeding in the court where the court perceives there are common questions. They may be questions of fact, they may be questions of law. And equally, it may be that the court sees situations where there's an action, maybe a counterclaim, or different issues within the action, and they should be separated out. So 3.32 says there may be multiple causes of action of multiple plaintiffs and defendants, and that may result in inconvenience, delay, or embarrassment. So it may split up an action. It may bring separate actions together. It may bring them back together, having previously split them up. So it's about as flexible as you might want it to be. All right, last points then. Actions by or against infants. Rule 32 is our relevant rule here. So these are people that are under a legal disability. So there's a connection to the impediment known as an empêchement de droit, which affects the running of prescription period. But if you are under this form of legal disability, then you cannot be a party to an action. You cannot intervene. You're just washed out of the proceedings. However, somebody may have been appointed to represent your interests. So that could be a tutor or a curator. Curator, probably if we're looking at an adult suffering with mental health problems. But if one of those has been appointed to represent their interest, then they will no longer be regarded as being under a disability, and certainly time will start to run, and they can conduct proceedings on behalf of the individual. If people cannot be ascertained, then it's possible to have somebody appointed to represent them. That can work either for plaintiffs or defendants, but it only exists in certain types of proceedings. So you can see those at 3.35. Estates of deceased, property subject to a trust, or meaning of the document, which would include an enactment. And you can be appointed to represent those who have yet to be born, those who cannot be found, those who cannot be whose identities cannot easily be ascertained, or if there's a class, so like a class representation there. Fairly straightforward in terms of application. The effect then, where someone has been appointed to represent others, this is 337. Any proposed settlement would need the court's approval. But if the court does make an order or gives a judgment in a case where a representative has been appointed, then generally speaking, that will bind all those who are represented there. But it can only be enforced with the leave of the court. There's a separate point as far as trustees, executors, and administrators are concerned, separate rule. So that's rule 35. Trustees, executors, and administrators may bring or defend an action in their capacity as such without the need to add any of the beneficiaries or those who have a beneficial interest. And a judgment that the court makes will bind the beneficiaries unless the court says differently. Right, shall we have a 5-minute break now? Okay, right, so Chapter 4, default judgment. A number of different points to consider here. We've got to look at, excuse me, judgments relating to election to domicile, which I think I mentioned earlier in terms of having to provide an address for service. Judgment for failure to appear at tabling. We've already thought about that a little bit, so it's just kind of pulling things together. Judgment on a counterclaim. Judgment against a third party. Judgment for non-compliance. And unless orders. So nothing that I think we have not already encountered, so perhaps we can take this fairly rapidly. So 4.2 then, when the plaintiff tables a cause, he has to include his address for service as per Rule 12. Obviously that address can be changed from time to time, but should give notice to the other parties and to the gref. Court has the power to order an address for service to be given or for it to be amended. What else do we need to think about there? Oh yeah, if the court satisfied service cannot be effected at the address that's been provided, it may actually dismiss the action or require the plaintiff to amend the information that's already been provided. Likewise, when the defendant turns up to the tabling of the cause, he has to give his address for service, and again, judgment in default can be entered against him if he fails to do so. Basically, it's tit for tat, effectively, exactly the same. So failing to appear, very straightforward. If the plaintiff doesn't appear when the matter is tabled, it's highly likely the court will dismiss the action, unless perhaps he's represented and there's some argument or explanation or excuse put forward by the advocate as to why they're not ready to go. If the defendant doesn't appear, as I say, there'd need to be a proof of service. Judgment on counterclaim, I think we've already dealt with that really, so I'm not going to say anything about that. Likewise, judgment against a third party, pretty sure we've covered that when we looked at third parties in chapter 3. So nothing new to add there. Non-compliance, 4.6, Rule 56. So it says there, although we did touch on this briefly, I think it's a little bit more detail here. So if the court makes an order or gives a direction, it will specify a consequence to follow if there's non-compliance. So there'd be a deadline, there'd be a sanction typically, and as it says there, in that situation, the parties cannot just take it upon themselves. Again, part of the court being an active case manager. So, excuse me, if there has been a specified sanction and the party doesn't comply, then that's probably that. But you can apply for relief against the prescribed sanction, and that's addressed in 4.7. So the application for relief has to have an affidavit in support, and that affidavit should address all of these points. So there's another nice long list for you, but it's not rocket science, it's all fairly straightforward. So for example, E, the extent to which otherwise the party's been a good party and done all the things that were required of them. Or F, who is culpable here? Is it the party that is causing issues by maybe giving conflicting or contradictory instructions, or not giving instructions at all, non-communication there? Or is it the advocate that's causing problems, perhaps not paying sufficient attention to the file, that type of thing. So that's a fairly lengthy list, but as I say, nothing I think that we couldn't have anticipated being there. Unless orders, we just looked at those, so don't think there's anything else that we need to consider there. So goodbye chapter 4. All right, injunctive and other forms of relief then. Generally then, we can think about the 1987 law, the Law Reform Miscellaneous Provisions, Guernsey law, but we should also note that customary law also applies in this area. So under the 87 law, there's the power to grant an interim injunction, either if proceedings are in existence or they are going to be instituted. And that's exercisable up to any point when a final judgment is made. As you can see, then powers exercisable by either the ordinary court or the matrimonial causes division. I'm not interested, as I said yesterday, in the matrimonial causes division, but anyway, they have those powers. And the ordinary court also has power to grant injunctions under customary law. Bless you. And you can see some examples in that first footnote there. So, as far as interim injunctions are concerned, then notice of application in accordance with Rule 81. So, applicant to serve a signification upon the respondent not less than 4 clear days before the date of the hearing of the application. Copy of the application, the draft order should be attached to the signification. as it says there, not all applications for injunctive relief, for not all of them would it be sensible to give the defendant advance notice of that. So things like freezing orders, search orders, that type of thing, you wouldn't want to give advance notice. So as it says, the 87 law provides that applications may be made without giving notice to the party that is intended should be bound by the injunction. As far as granting the injunction, just and convenient are the key words there, whatever they mean. Going to depend on the facts of each case, I suppose. And applicant may well be required to enter into undertakings offering security for costs, reimbursing expenses in particular situations, serving the signification forthwith. And so you can see there, for example, if proceedings have not yet been commenced, a standard undertaking would be to commence proceedings within the time specified by the court in that particular case. And again, a very standard undertaking to pay damages to the other party for any losses sustained as a result of the injunction, if when it comes to a hearing, the court decides that the injunction should not have been granted. Sanctions for disobedience. Generally, the sanction is that the disobedient party will be held to be in contempt of court and be liable to be punished on that basis. But the injunction itself may prescribe a penalty for non-compliance or other form of contravention. As it says, if the applicant considers that the respondent is guilty of a contempt of court or that a specified penalty should be enforced, then issues a summons to start those default proceedings. Interestingly, if the court has specified a penalty and finds that indeed there has been non-compliance and exacts the penalty, then that, if it's a pecuniary one, will be payable to the applicant. The injunction lasts either until the court discharges it or it reaches a final judgment in the case, or the proceedings are otherwise concluded, or if there's a specified time or some other event, then that has come to pass. So again, fairly usually, anybody can apply to the court to vary the injunction or to discharge it, or to vary or discharge any condition, penalty, or undertaking associated with it. That's probably that. As far as the approach of the court is concerned, things for us to think about. All right, so we need to distinguish, again, I'm sure you're familiar with this, distinguish between prohibitory and mandatory injunctions. So 5.9 in terms of an interlocutory prohibitory injunction, this court will normally abide by the principles set out in a very old and well-known case of American Cyanamid against Ethicon, which is of course an English case. And you have an example where those principles were applied back in 2012 in Cobra Business Ventures and Greenfield Capital Limited. So is there a serious issue to be tried? If there is, would damages be an adequate remedy? If not, where is the balance of convenience? And if balance of convenience is neutral on that, then there's likely to be status quo and therefore no order made. If the court's being asked to make somebody do something, so a mandatory injunction, then again, as is quite normal, there is a stricter test to apply here. And I think the Technocom and Roscom Limited and Clubbin case is quite an interesting and informative one as far as mandatory injunctions are concerned. You've got these points then. Court will look at the length of time it's likely to pass between the interlocutory proceedings, specifically, I guess, the hearing date today, and the full trial when that's been set down for, assuming that it has been. Any losses that are likely to be incurred in that period in the run-up to the trial, and therefore whether damages might be appropriate and affordable if the injunction is overturned. Would it be helpful to just leave things as they are and maintain the status quo up until the trial? How likely is it the applicant would establish his rights at the trial? And as you can see in that footnote there, the greater the degree of assurance the plaintiff will ultimately establish his right, the less will be the risk of injustice if the injunction is granted. So that was cited in the Technicom and Roscom case, and I guess it's probably quite reassuring then if you do get a mandatory injunction, the court is already beginning to look favourably on your chances of success there. So also likelihood of compliance with the terms of the injunction and ease of supervision. So what could the court do to make sure that compliance is taking place, and any delay, as is so often the case with interim or interlocutory matters, court's very keen to see that people are acting promptly. Okay, appeals. This is just a question of divining. I think we did touch on this yesterday, if memory serves me correctly. So is it an interlocutory decision or a final decision? If it's an interlocutory decision, then you'll need to get leave to appeal to the Court of Appeal. If it's a final decision, then you don't need to get leave. You may, of course, not know that. So you may end up just appealing and then being told that you need to apply for leave first. All right. Yeah. Yeah. Okay. All right. So freezing orders then, somewhat appropriately. Sorry. So yes, freezing orders. So applicant wishes to respond to be restrained from dealing with or otherwise disposing of assets located within the court's jurisdiction. So this could be dissipating, selling them, destroying them, hiding them, try to transfer property rights over them. The main objective, of course, being to try and, so the applicant would argue, frustrate their possible judgment against the defendant. So as it says, total sum to be covered by a freezing order likely therefore to be capped at the maximum amount of damages claimed or to be claimed against the defendant, which of course is fine where there's a liquidated sum being claimed, but maybe more flexibility in other situations. So freezing order will often be used where one has identified specific assets that are associated with an intended action. As it says, the application is typically made without notice to the other party and therefore also even before the proceedings have been commenced, because otherwise, if you are concerned there's a real risk of dissipation or destruction, then if you're correct in that diagnosis and you tell them you're going to make the application, then the thing will be destroyed or dissipated or hidden away somewhere. So it's kind of, self-perpetuating thing. So 5.13 then. The relevant jurisdiction is still Section 1 of the 1987 law, if proceedings have already started or will be started. It is also possible, although exceptionally, I think we have to recognise that this is an exceptional procedure anyway here, but even in this situation, exceptionally, the court may grant a freezing order where proceedings haven't been started within the bailiwick, and nobody intends to start them there either. So you can see that's within Section 1, subsection 7 of the 1987 law. So it says that situation may arise where a judgment has already been given. So this would be a post-judgment application for a freezing order to protect assets that are within the bailiwick because the party wishes to enforce a judgment given by a foreign court. As it says, they're somewhat more tenuously, we may be even further afield than that. So the freezing order may be designed to protect assets within the jurisdiction against a possible future enforcement should that party then get judgment in the foreign proceedings. So that is becoming more and more speculative there. It's also theoretically possible, when we come back in the footnote to our old friend from yesterday, Seed International against Tracy. Also possible then to get a worldwide freezing order. Okay, approach of the court. Well, you can see Court of Appeal in Seed International there. Essential question is whether there's an abuse to be prevented. So for the court to make a freezing order and its associated disclosure order, it's for the applicant to show he has a good argument case, that there's a real and sufficiently serious risk of dissipation of assets within the jurisdiction, and it's just and convenient to make the order sought. There will, of course, be subsequently an inter partes or with notice hearing. So when the order is executed, there should be a return date for that. Freezing order will be limited in its duration, although it may be a long period, as it says there. Court is entitled to see defendant is not unduly kept out of his assets. So you have to crack on if you're the plaintiff here. Yes, Solvolub. I've put that in there because the Guernsey court has adopted the approach of the Jersey Court of Appeal in the Solvolub case. So as far as that's concerned, this court is like to make a freezing order rather than see Guernsey acquire a reputation as a safe haven for those that wish to dodge their responsibilities or legal liabilities. All right, 516, it shouldn't be oppressive in its ambit or operation, although obviously there are elements of that in it. So for example, a reasonable amount for monthly living expenses, assuming that there are no other available assets for the defendant to discharge for that purpose. Disclosure orders, I did mention those briefly yesterday. So it's not at all unusual for an application for both a freezing order and a disclosure order to run together, because of course for the freezing order to be effective, it needs to have some identifiable assets to freeze. So again, back to our old friend Seed International, where the Court of Appeal noted the words of the then Lord Justice Steyn in Grupo Torres versus Sheikh Fahad Mohammed Al Sabah, stressing that in a case like this, unless the court could make a sufficiently wide disclosure order, the freezing order might be a relatively toothless procedure. Yeah, and he's quite a nice little quote, I think, from Lawrence Collins, as he then was. Now I think Lord Justice Collins. Anyway, yeah. So there you go. So yeah, we don't want a toothless freezing order. I'm not quite sure what one of those looks like, but anyway, there you go. And I think that's that. 5.19, perhaps important here. Just again, coming back to a point that we did look at yesterday in terms of when you get information, what you're allowed to do with it. So as it says there, typically the disclosure order will have a proviso that the information that is disclosed by the defendant as a result of the order may only be used for the purpose of the legal proceedings between the parties. However, on application, the court may remove that limitation. Right, search orders. Okay, so these are also a very draconian power that the court has. So as it says there, these are orders, and we know what search orders are, don't we? Yeah. Purpose of preserving evidence which might otherwise be destroyed or concealed, originating from the Anton Pillar case back in the 1970s. But yeah, at the outer limits of the court's jurisdiction. So it says there are few, if any, examples reported as far as Guernsey case law is concerned. So how does it work procedurally? Application, affidavit, or supported by an affidavit and a draft order. Again, just like with the freezing order, you'll probably be making this application without notice and before the commencement of proceedings against the defendant, because you want to take them by surprise. Seen as a remedy of last resort, if any other less drastic method can be identified, then that's what should be used instead. And I guess the point there is that that's something that the judge on the without notice application may well be canvassing with the applicant's advocate. Is there something else that you can think of that might achieve the same benefit or outcome? So as you can see in what is my footnote 31, it says, for example, in order for the defendant to deliver up the allegedly infringing articles. Because very often, of course, the allegation is that these are things that are in breach of some intellectual property right, that type of thing. Pirate videos. Well, they probably don't exist. Pirate, will they be DVDs? Pirate USB sticks, pirate streaming. Yeah. Oh yeah. All right. So yeah, no. How could you deliver up a Greek Premier League channel? I don't know how that would work. But anyway, yeah. So maybe in that situation there is no less drastic alternative. But as it says there, the little quote from as he then was a long time ago, Mr. Justice Hoffman, in Locke International, must be proportionality between the perceived threat to the applicant's rights and the remedy to be granted. So what does our applicant have to do? Well, according to that little 5-point list, has to show an extremely strong prima facie case, and we note in that footnote there, this is seen as a more onerous requirement than the merely good arguable case that the freezing order required. So this is, presumably therefore even more draconian than the freezing order is. So extremely strong prima facie case that the damage will be very serious for him, clear evidence that the respondent has incriminating material, real risk that the evidence would be destroyed if the application were to be made with notice, and the likely harm to the respondent and or his business is not disproportionate to the legitimate object of the order. Okay, and it would be usual, certainly in England and Wales, for there to be the standard undertaking in damages, should it turn out that the order should not have been made, a bit further down the track. And other undertakings that would be quite standard would be to have a return date for a hearing on notice, usually within a very short time indeed, and an undertaking to commence a substantive proceedings either that same day as the order, the search order is made, or the next working day. As it says at 522, since there are not many of these in this jurisdiction, the likelihood is that the court here will follow the basic scheme that's set out in the civil procedure rules in England and Wales, but making certain adjustments. So you can see, for example, whereas execution in England and Wales, and I think I'm right in saying in Jersey as well, would be under a supervising solicitor to oversee that. That won't happen here. It will be supervised by Her Majesty's Sergeant. Standard point about the respondent being able to and should be told that he is able to seek legal advice before submitting to the order, and obviously can seek variation or discharge of that before it's executed. Again, a slight difference here. So the applicant's advocate will make a report to the court about the execution of the order, not the sergeant, although he's or she is supervising this. And again, usually, and when I say usually, I mean in England and Wales and in Jersey, it would be the supervising solicitor that would make the report to the court. Yeah. Potato, really. Right, so that's that on search orders. So they exist, you can apply for them, but there haven't been many examples of that. And I think the last thing for this chapter, oh no, I'm getting ahead of myself. Sorry, I take that back. The next thing for this chapter is the anti-suit injunction. Okay. So anti-suit, as it says, what's the idea of the anti-suit injunction? Put a stop to legal proceedings somewhere else, somewhere outside of the bailiwick. All right. They may be ongoing, they may be intended but haven't yet commenced. Okay. So the Royal Court clearly feels that it has the jurisdiction to grant an anti-suit injunction, and that might be because there is a contract claim or a claim arising out of an agreement of some sort that contains a jurisdiction clause, an exclusive jurisdiction clause, that type of thing. And again, I think the first footnote reference there, 35, first footnote reference is to some litigation that, again, crops up time and again, certainly around this area, which is the Winnetka Trading Corporation and Bank Julius Baer case. Thing to note, an anti-suit injunction injuncts the individual. It doesn't injunct the foreign court. There are issues around comity and relations between states and courts there. So the Guernsey court would not try, doesn't regard itself as having the power to injunct a foreign court. So it's injuncting the individual who either has started proceedings elsewhere or wishes to start proceedings elsewhere. Okay, but we'll investigate that in a little more depth. So as you can see then, the Royal Court has adopted a statement from the English courts in Royal Bank of Scotland and Hicks from 2011, that there are two broad categories, two broad types of anti-suit injunction. Those where there is some equitable or legal right that is being enforced to make sure that the proceedings are brought in Guernsey and therefore not somewhere else. And that might well be an exclusive jurisdiction clause in the contract. Or alternatively, simply cases where it would be unconscionable, oppressive, or vexatious for proceedings to either continue or to be started in some foreign court. Right, there are various statements of approaches here. So approach to the court, 5.24, you have Court of Appeal in Ashton and Ansell from 2003, but also some thoughts, it's getting very complicated, Credit Suisse against Nemney in 2012, where the ordinary court adopted a set of principles that have been set out in the English case of Highland Crusader offshore against Deutsche Bank. So let's just kind of run through those in turn then. So according to the Court of Appeal in Ashton and Ansell, what the applicant for the anti-suit injunction has to show is that to allow the respondent to pursue their litigation outside of the jurisdiction would be vexatious and oppressive. Also, and this is heading back into forum convenience territory, although it doesn't explicitly say that there, that the Royal Court here is the clear and natural forum for resolution of the dispute. And again, that kind of balancing act there, injustice to the applicant, if the respondent were to be allowed to pursue the foreign proceedings, would outweigh any injustice to the respondent if ordered to stop them. So as you can see on the facts of the Ashton case, and I think it probably is worth the read, it's not a very complicated factual case. The dispute in England was ancillary to the one in Guernsey, being described as satellite litigation. Seeking to pursue that was vexatious and a waste of time and the party's money. There'd be no injustice to the respondent, requiring it to address all of its relevant disputes within the overall Guernsey action, but obvious injustice to the applicant having to pursue parallel proceedings effectively. I think one of the main considerations in the Ashton and Ansell case was the location of witnesses, but bear in mind they were only in England. You know, coming to Guernsey was not going to be the hardest burden to place on them, so that wasn't really a very compelling argument from the defendants there. All right, so 5.25 then, Credit Suisse ordinary court has adopted these principles set out by Lord Justice Toulson. The stronger the connection of the foreign court with the parties and the subject matter of the dispute, the stronger the argument against intervention. In other words, the anti-suit injunction would not be granted in that situation. Also an observation that parallel proceedings are not desirable, but on the other hand, they're not necessarily vexatious or oppressive, so it's not kind of an automatic judgment to be reached there. And ultimately, the decision is a discretionary one. The court needs to be flexible about that. The other point to note, and again, it's kind of a recurring theme here, is I think towards the end of that paragraph in 525, what I'm going to call the need for speed. As it says there, if you are seeking an anti-suit injunction, you should do so promptly. I mean, the court's always looking for prompt action as far as interlocutory applications or interim applications are concerned, but do so promptly before the foreign proceedings are too far advanced. Although obviously what that means in any given case could be quite variable. Yeah. So in other words, if you are going to be seeking an anti-suit order, don't hang around. All right, it's also possible to have a post-judgment anti-suit order, and that's picked up in paragraph 526. And obviously the idea there is that you don't want to, and this does happen from time to time, you don't want a defendant who has lost in the court in Guernsey to then go off and start new proceedings somewhere else with the aim of then frustrating or effectively overturning the judgment that's already been obtained in Guernsey. And I would have thought that's a situation where the court's going to be far more inclined to make the order sought. Well, it's said, yeah, you will be served. Yeah, you will be served with that. Yeah, yeah. Which would then, well, one of the things I think we do actually come back and look at these in a later chapter. I need to reorganize things a little bit, but there's a reference in the later chapter to the party that you're seeking to restrain having to be amenable to the jurisdiction of the court. In other words, there has to be some realistic prospect of somehow exercising control over that individual. It's not like the court, you know, the judge in the ordinary court kind of writes a nice letter to you know, the judge somewhere else, says, please, you know, I humbly request, or, you know, respectfully beseech you. That's not how it works. So it is specifically against the individual. And I guess, excuse me, I guess that you might find that if the party that you're seeking to restrain has, I mean, there might be sanctions imposed or sanctions identified, and if the defendant has assets within the bailiwick, then you might seek to enforce a penalty or a sanction against those assets. But I mean, it is difficult. I mean, the most obvious example that springs to my mind is the Crociani stuff from Jersey, because you had them. I mean, it's a very blatant attempt. Sorry, it's being recorded. Let me reconsider that. It was a misguided attempt to launch parallel proceedings. I think it was in Mauritius, wasn't it? There was a lot of movement around going on there. I mean, the law of the trust kept changing over time. Trustees came and went. I mean, that I think is an interesting example of maybe what would affect. I don't think they actually had an application in Crociani, although they did many things. I don't think they had an application for an anti-suit injunction. They certainly had a lot of plenty. Well, I think they went up to the Judicial Committee on Forum Non-Convenience, if memory serves me correctly. But you know, realistically, all that you're doing is saying to the restrained party, you must not do this. And if the restrained party goes, I couldn't give a donut about what you think I should or shouldn't do, I'm going to go ahead and do it, then you are kind of stuck. I mean, obviously, the foreign court, yes. Well, that's the other side of it. That the winner here would then have to go over there and say, I'm not submitting to your jurisdiction, but look, this is how things stand at my end. So what are you going to say about that? But ignore it. Yeah. Well, I think that's what the Mauritian court was doing in Crociani for quite a while anyway. Yeah. I don't think it's doing it anymore, but. Right. Okay. So, oh yes, our old friend, the Clamor de Aro. Okay. Survivor, as it says there, of customary law, unbelievably still being used from time to time. I think last recorded one was, right, I haven't come across, or maybe I did come across that, but I certainly came across one in 2016. Yeah. No, was that the one that the verge was being dug up? Was that the one? Hmm. Yeah. Right. Yeah. No, I think I did see that actually. But yeah. Yeah. No. You have to be the owner or occupier of the land. Yeah. Highway. Yeah. Oh yeah. 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 Because it hadn't been taxed. Was that the one? Yeah. They wanted to tow it away. Yeah. 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 Right, because they're about to be disconnected or cut off. Yeah. Yeah. Yes, the lights have gone out all over Sark. Yeah. Oh dear. Yeah. Strange situation. Though. All right. So clamour. Well, all right. I mean, I think it's realistically of only kind of legal academic interest, really. But let's work through it. So procedure set out in 528. You've got all the important stuff there. You've also got the Lord's Prayer in French, set out in Dawes's Laws of Guernsey at Appendix 8. So as it says there, it's to restrain wrongful interference with land when the interference is imminent or actually occurring. So typically there is a lot of confused men with pitchforks. What do I know? Pickaxes. That's it. Pickaxes. Standing around going, what the hell's going on here then? Possibly speaking to each other in, I don't know, Polish, Russian, Portuguese, etc., etc. People in high-vis jackets anyway. So, all right. So, as it says there, obviously, if the alleged wrongdoer ignores the clamour and continues, then risk of being found in contempt. And obviously, it's kind of source for the goose being source for the gander. If the clamour is raised incorrectly, then you're liable, potentially at least on an indemnity basis, to the people that you have improperly restrained. You've got 24 hours to come, and we were talking about registering. 24 hours to come and register the clamour by an appearance before the bailiff, preferably with witnesses who can testify as to the successful and accurate raising of the clamour. As it says, if that doesn't happen, then the thing won't be registered. Excuse me, my voice seems to be going, but we'll see if it can come back. And then if it is registered by the bailiff, a year and a day to begin an action in the Royal Court to confirm its terms and whatever the remedy that is being sought against the defendant. All right, arrets, arrays. What do we call them here? Arrays? Arret, okay. All right, so various types, 4 types. So there is the arret conservatoire, exécution, dégage, or dégage, and des personnes. So I've noted there that Dawes, in his book, had the view that the exécution and dégage were commonplace. The first, the conservatoire or simple arret, overtaken by freezing or search orders, and arret des personnes, really kind of separate category in themselves. So let's just quickly run through those. So technically, the arret conservatoire is freezing respondents' assets to await the outcome of the applicant's claim. Only applies against personality, and as it says, they're probably only respective of a liquidated sum. However, it does apply in rem, unlike the freezing order, which is in personam. So you can get an arret against a bank where the defendant has an account, and the conditions for it are the plaintiff is a cause of action in Guernsey. The putative defendant indeed has property in Guernsey, which is capable of being arrested, and good grounds for believing that if it's not arrested, it will be taken out of the jurisdiction. Yes. I think so. Yeah. All right. Arret execution is post judgment, so it's to deal with where there's a judgment debtor. Yeah, Laurel. Yeah.
It seems like.
Yeah.
I would have known the device to use it.
Interesting. Okay. All right. Yeah. So yes. All right. Judgment debt. So as it says there, if the judgment remains unsatisfied, the judgment creditor delivers the active court to the sheriff with a statement of costs. Sheriff then arrests the personality of the judgment debtor, obviously simply by taking walking possession. So basically going and doing an inventory of the property. If the debt still, if that hasn't jogged the judgment debtor to actually pay and satisfy the judgment debt, then the judgment creditor applies to the royal court through a summons served on both the judgment debtor, who's the one that owes the money, and the sheriff, who's the one that's taken walking possession of the debtor's property, to have confirmation of the arret, and then in order that the property be sold until the judgment has been satisfied, along with costs. All right, the arret de gage is just, as it says there, arrest of a worker's wages, so it's like an attachment of earnings order. In fact, I think it is an attachment of earnings order. And some of the material you'll see it's described as a wage arrest order. And I meant to pick this up yesterday, and unfortunately, my computer can't get on the internet here for some reason. And when I tried to do it on this laptop, it didn't like it because the recording was going on. But so I'll have to do this from memory. There is provision for somebody who has been made the subject of a wage arrest order, or indeed somebody who's been refused the making of a wage arrest order, to appeal against either the making or the refusal of the order to the magistrates court, PDC, I suppose, strictly speaking. So in that rather peculiar niche area, the PDC can act as effectively an appellate court. Yeah. As you can see in the opinion of Mr. Dawes, these sorts of orders are ineffective, both ineffective and unavailable against the self-employed. So, I suppose that's probably self-evident, really, given the fluctuating nature of self-employed income. And then the last one here, last bit of chapter 5 as well, the arret des personnes. So this is imprisonment for debt, which apparently is still a thing here. So yes, come back, Charles Dickens, all is forgiven. Yes, so as you can see, it's not that long ago. Look, law relating to debtors and renunciation, 1929. So no one should be subject to imprisonment. That's what the law said for debt, unless it's permitted by law. Tragically, 4 exceptions have been identified where it is permitted by law. They're all, I think, fairly clear. The theory being that if you are under threat of being arrested and then thrown into some sort of custody, then that will give you the motivation to pay off the debt that you owe. For obvious reasons, it will be necessary for an applicant seeking this arret to show evidence that the defendant does actually have the wherewithal to pay off the debt. As it says there, the object is not punishment, but enforcement. So under Article 3 of the 1929 law, the imprisonment may be ordered for up to 6 weeks or until the debt is satisfied. And it's not even like in crime, where you can have like a term of imprisonment in default of payment of a fine, because at least then you serve the time, you don't have to pay the fine. Here, you serve the time, you still have to pay. So it's kind of a lose-lose situation, really. But there we go. as it says, there are, I think, fairly obvious tensions with Article 5 of the European Convention, here, right to liberty, fairly self-evidently. But there's a similar procedure, SASE, that operates in Jersey, and that got taken off to the court in Strasbourg in a case called Dick against the United Kingdom. The Strasbourg court said there were sufficient safeguards there that it was actually Article 5 compliant. Yeah. So yeah, I don't even know where they'd hold you with this. I mean, presumably not the state's prison. It might be a bit unpleasant. Although that might is it? Oh, is it? Oh, good. Well, I was going to say, I thought you might say more pleasant than no. We're not going to go there. No. All right. Good. So that's chapter 5. Yes. Ineffective.
No, but against self-employed. Yeah, that's the same in England, because you're relying on employing self-employed.
Yeah, it's slightly ambiguous, but that's how I read it. Yeah. Yeah. Well, yeah.
And they're quite strict. In England, they're quite straightforward. I've never been here, but it's just it's a form and you fill it on.
Yeah.
But probably the next day.
But none of the other.
Which doesn't ring any bells.
Because I mean, if you sort of were a bit too casual about these, you know what I mean?
I guess the executional assets, that's quite useful.
Yeah, the second one. Yeah.
Yeah, that's what I'm thinking. Yeah. Yeah, precisely.
Well, usually in England, we would arrest an asset and pay it all the time. When they actually, you see, can't pay, taken away, it's actually effective. You know, you'll go to somebody's house and there'll be a TV.
You've got a resale.
Whereas here, you would probably do it if someone had a phone or a car, but then those things are not going to be on fire. So it's not effective.
An article about rogue bailiffs.
Yeah. Oh, yeah.
Rogue bailiff, Guernsey edition.
I see an idea for it.
Yeah. And Ben, can I just ask you, you mentioned that you guys.
New reforms set to curb aggressive behavior of rogue bailiffs who terrorize debt-ridden families.
Was that in England?
All right.
Yes. Why did you guys?
Because our point was it's simpler than a freezing injunction, administratively or otherwise. And the client said, well, we're familiar with freezing injunctions, just do that. Right, this customary law stuff makes sense. Right. Gordon was like, damn it. Yeah.
Right. Okay. So, well, on to chapter 6. Yeah. Okay. So, all right. Chapter 6. Yes. Interestingly, entitled prescription and limitation. The first thing that I say there is you need to distinguish these two different concepts. So, as you can see, limitation period in England and Wales bars they're the claimant here, the plaintiff, from access to a remedy, whereas prescription actually extinguishes the claim itself, so it can wipe out rights. Yeah. So as it says, it's in English law possible to plead a right as a defence where the limitation period has expired, because that's not what limitation does. It doesn't extinguish the right, which means that you can't, as it says there, access the remedy. So you can plead it as a defence even once the limitation period is expired, if that makes factual sense in your case. But as it says here, after prescription, after a matter has become prescribed, not only is there no access to a remedy, but the right doesn't exist anymore. It's gone. Okay. And it said that this difference results from the fact that limitation is procedural law, but prescription is substantive law of the dispute. Okay. I see I've quoted there an article in the Jersey and Guernsey Law Review, doubting that distinction. So, you know. Oh yeah. What you mean you have to plead the prescription point? Yeah. 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 Well, yeah, because nobody knows about it. Yeah. Well, I say nobody. Somebody knows about it, but not everybody knows about it. Okay. Right. So yes, joining up the dots a bit. Prescription is pleaded as an exception de forme, which takes us back to chapter 3. And as it says, plaintiff probably needs to come back by way of a replique to that. And that replique will either suggest that time didn't start to run when the defendant said it did, or the plaintiff is claiming some sort of impediment that means that time doesn't run against them. Yes, okay, so, all right, yes, positive and negative prescription. So we're back to customary law here. So there is the prescription acquisitive or prescription extinctive. And prescription acquisitive, as it says, covers situations where a fluxion of time leads to the acquisition of a right. So like adverse possession, yeah, where you've been somewhere for, was it 12 years? Landowner hasn't sorted, yeah. Yeah. So basically, the limitation point there means that you cannot, if the limitation period is expired, then the plaintiff can't go ahead, right? So they're stopped. But if you could envisage a situation, I can't off the top of my head, but if you could envisage a situation where it was beneficial as a defence to say that the limitation period has expired, and I'm using that to assist me defensively, then that would be all right, because you're not seeking to access justice there. So you're not seeking to access a remedy. Okay, so it's not being used, if you like. Think about it offensively and defensively. It's not being used offensively. You can't do that anymore because the limitation period is expired, but you can still use it defensively, right? So it's become of limited potential benefit. Whereas the point here is it's not capable of being used in any shape or form, offensively or defensively, because the right doesn't exist. It's gone. Yeah, it's just evaporated off into the ether. Okay. So yeah, all right. So positive prescription means that as time has passed, I have acquired a right, something like adverse, adverse possession. occupying a field for a number of years, it becomes your field. Well, all right, so maybe not the fields, but certainly, yeah. So anyway, all right, so positive or negative. As it says, if you can establish it over the relevant period, allows the person who has used that right to acquire it, and it extinguishes the former holder's title to that right. And as it says, it's a little bit like adverse possession applying to realty. Whereas the latter, the prescription extinctive, is situations where the passage of time has destroyed rights. Although, of course, as you can see in the first example, as I acquire a right, I am necessarily destroying or extinguishing your right. Yeah, so they often go hand in hand. So as far as different rights are concerned, we need, as it says there, to make, I think it's 3 distinctions between droit réel immobilier, or real property rights, droit personnel, personal rights, for example, arising under a contract, and droit réel mobilier, or movable property rights. So for real property rights, it is said, and I stand open to contradiction, it is said that prescription acquisitive can apply here. Simple non-use of the right doesn't lead to its loss, but if another uses it without challenge, the original title may be lost due to the newcomer acquiring this new prescriptive title. And as it says, this can apply to the ownership of land or to usufruct, but not to servitude, which I must have understood when I wrote it. There's not a lot coming through in the old brain at the moment. I know there was an interesting case, which I think is the one that's in that footnote at the bottom of that page, assuming that your pagination is the same as mine, even if your footnotes aren't, that references Singleton and Lenuri, and also the Dukeman case. But yeah, right of way over a drive. Yes. Mm. Mm. Yeah. But no, I mean, so things like rights of way, potentially. I mean, at least according to the case law anyway. So.
Yeah. Yeah.
Mm. Yeah. Okay. So as you can see there, the basic prescription period there is 20 years of continuous possession. Heirs of real property, no, I'll put a real property there, heirs of real property, seeking to recoup it from a bona fide purchaser for value, have 6 years, but only have 6 years from the date of acquisition to seek to recoup it. All right, personal rights, rights personal to the individual, as it says, generally founded on law of obligations. So right to demand performance of the contract or claim damages as a remedy for some cautious act, that type of thing. And lastly, movable property rights to cover rights to company shares or to a car, etc. So prescription extinctive, I don't know why I find that so difficult to say, applies to those latter two, droit personnel and droit réel mobilier. So as it says there, the person will have only a finite time within which to exercise the right, or it will be lost. And that time for claims in contract and tort is generally 6 years. Okay. However, in a term that mirrors, I think, the position in England and Wales, if it's a death or PI case, then it's 3 years from the date on which the cause of action accrued, or if later, the date of the plaintiff's knowledge. And that 3 year period may be set aside by the court if they consider that it would be equitable to do that. Prejudice is the basic consideration there, so balancing the prejudice, the extent to which, if they shortened the period, that would prejudice the plaintiff, or if they extended it, that would prejudice the defendant. So as you can see, there are factors. Again, the old point about delay not being a good idea. So how long is the plaintiff delayed? What are his reasons? Has the evidence, quality of the evidence deteriorated there? defendant's conduct, so have they somehow aggravated the delay and therefore extended the period of time. Any disability that the plaintiff was suffering from, which arose after the date on which the cause of action had accrued. Again, kind of related to the delay thing, the extent to which the plaintiff acted promptly and reasonably once he knew that he should be making a claim, or the grounds on which the claim might be made, and any steps to get expert evidence, and also looking at the nature of any advice that you might have been given. So, for example, if he was advised by experts that he didn't have a claim to make, then that might be a material consideration. Right. Date of knowledge. So there are kind of interferences of the law with the facts as far as death and PI are concerned. So as we can see in 6.5, for fatal accidents and PI cases, the Port of Guernsey law provides that reference to when somebody knew something refers to the date when they first knew all of the following facts. So that's A, B, C, and D. Yeah. So there was a significant injury. That injury was attributable either in whole or part to an act or omission that is alleged to be negligent or nuisance or breach of some kind of duty. Who the defendant is, and where it's alleged the act or omission was someone other than the defendant, the identity of that other person, and the additional facts that support making a claim not against them, but against the defendant. Also, you can have deemed knowledge, so 6.6 explores that, also under the 1979 law. So as it says, knowledge referred to will include such knowledge as he might reasonably have been expected to acquire from any facts that were observable by him or otherwise ascertainable by him. So not things that he did observe or had ascertained, but things that he could have, or from any facts that would have been ascertainable by him with expert advice that it would have been reasonable for him to seek. So as it says, where he has actually taken all reasonable steps and obtained expert advice and acted on it, then he won't be deemed to have knowledge of other facts that would have been also ascertainable only with expert advice. But obviously that can cause quite significant issues as far as plaintiffs are concerned. All right, interruption. Maybe let's have a look how much we. So if we, yeah, I think if we finish chapter 7 and then break for lunch, there. So interruption is not really an interruption. It's a reset. Yeah. So prescriptive period will be interrupted by the commencement of an action, but it doesn't, as I say, kind of like the clock doesn't stop; it gets reset. So as it says, if the possessor of land loses possession for more than a year, prescriptive period is interrupted. If the possessor pays rent or in some other way acknowledges the true owner's rights over the property, then prescription is interrupted. So you have to reset and start again. Okay. So all right, actual suspension dealt with. Oh yeah, sorry, I also apologise. My paragraph numbering has gone awry again here. So sorry about that. But yeah, actual suspension then, as it says, there merely pauses prescriptive period, doesn't reset it. So something like that, as it says, would be the potential plaintiff is under some sort of obstacle, which may be an incapacity. They may be a minor and therefore legally prevented from acting. They may be suffering from some mental health issue and therefore just incapacitated. Or it may, of course, be, in the light of what we're just looking at with the death and PI situation, they have a lack of knowledge that would permit them to make a claim. So as it says, sometimes, as we've already seen, you can overcome that by appointing somebody to act on their behalf. I've said a guardian here, but we've also mentioned earlier the tutor and the curator. In that situation where someone is appointed to represent their interests, then prescriptive period resumes. Otherwise, it is suspended for the duration of the impediment, however long that is. Obviously, with a minor, it's till they reach their 18th birthday, or if it's someone with a mental health issue, they cease suffering from that issue. Right, nothing else I want to say about that. All right, so generally these impediments are known as empêchement d'agir, or impediment to action, and then they subdivide into empêchement de droit or empêchement de fait. Empêchement de droit, of course, meaning a legal impediment, so it's one that the law has decided will act as an impediment. Empêchement de fait, obviously being just on the facts of that particular situation, there is an impediment to action. So what else do we need to think about that we haven't already mentioned? Yep.
Found that there was an empêchement d'agir by somebody to uphold his right under a contract.
Mm-hmm.
Because he wasn't
Okay. Right. No, okay. Cool.
And that apply to all these cases.
Good, thank you. Thank you for that. Right, okay, what else have we got? All right, yeah, so 6.8, statutory examples then. So in the Tort Guernsey Law, section 9, where a right of action has accrued and a limitation period has been laid down by the law for that right of action, the action will not be prescribed until 6 years following the date on which the person ceased to be under their disability or has died, whichever is the earlier. Section 11 of the Tort Guernsey Law postpones commencement of any limitation period under the law where the action is based upon fraud. Yes, so based upon the fraud of the defendant or the right of action has been concealed by fraud, or the action is brought seeking relief from consequences of a mistake. So obviously, and I think this is not unusual, the prescription period won't run until the time when either the plaintiff has discovered the fraud or mistake, or when reasonable diligence would have enabled him to have done so. So that's two examples. The third example, under the Trusts Guernsey Law of 2007, as it says, no prescriptive period for an action against a trustee where there's an allegation of fraud against the trustee. In other situations, action for breach of trust has a prescriptive period of 18 years following the date of the alleged breach. As it says, that is a long stop and might be shortened in particular circumstances down to 3 years. By the court. So, empêchement de fait, the Yadahiga case, I think I've mentioned that many times, both yesterday and today. That is, a handy case to have a look at. But you can see there's a reference, it's a Court of Appeal case, reference to a couple of cases from Jersey. So, Public Services Committee against Maynard. Mere ignorance doesn't bring the maxim about impediment into operation. Where there is an impediment that creates a practical impossibility, then the maxim may come into operation and prevent the time running. All right, and then Boyd and Pickersgill. Practical, what's practical to do? Practical impossibility softens rather than strengthens the concept of impossibility. Requires a consideration of what, is, in fact and not in theory possible. And then there's a very nice quote from the Court of Appeal in Yadahiga. They're saying that empêchement d'agir appears to develop what might be called an equitable remedy. and the courts, the island courts, had never formally distinguished between law and equity in the ways that English courts did, but that doesn't mean to say that they didn't operate along similar lines. All right. Okay. So that is that. Let me just check something. So, I've done all that. Yep. Okay. Case management. Yeah. All right. Yeah. Chapter 7 is going to take us a little while, so I think we probably do need to have our break now. Otherwise, we'll just be confusing me.